Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding, we thine unworthy servants here gathered together in thy name do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that we, having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity one towards another, through Jesus Christ our Lord. Amen.
This meeting of the Honourable Senate of Jamaica for Friday, January the 22nd, 2021 is called to order. Before we begin the business of the day, I just bring to the attention of our members the preferment of one of our own, Dr. Sapphire Longmore, who was recently elected as the president of the Psychiatric Association of Jamaica. It's an organization of highly specialized medical professionals in the area of mental health management. And I was just looking at the list of past presidents, and I'm surprised to note how many of them I know so well. Including, of course, Mr. Wendell Abel, who worked in the prison system for many years, Dr. Irons, who most of you know as Agri, and Professor Hicklin, so she is in grand company. So all the best, and we are sure that the enthusiasm that you demonstrate here, that if you take it into that association, it will be for the benefit of all, not only those who require your attention. Statements by ministers.
If I might, Mr. President, just to add a few words and not to delay, but just to add personal congratulations, and indeed congratulations on the part of this House. Members of this Honourable Chamber would recognize by just a quick walk down memory lane that in every Joint Select Committee, in every bill, in every matter that has come before this Senate that could possibly have a mental health aspect or a concern about the welfare, the well-being, indeed, of the Jamaican people, expressions of humanity, and certainly the need to ensure that we have a more sensitive society that considers in every way the mental well-being of our population. Senator Sapphire Longmore, Senator Dr. Sapphire Longmore has brought those issues to this chamber. So it is with pride we welcome your announcement this morning, Mr. President, and indeed wish her every success in this new, with this new hat that she'll be wearing. We expect the best, and we know she will deliver it. Thank you, Mr. President.
Thank you, leader, Senator Scott Motley.
Mr. President, it would be remiss of me if I did not take this opportunity to congratulate Senator Dr. Sapphire Longmore. As the Minister has so eloquently said, we have sat in a number of joint select committees together, at which Senator Johnson Smith has also been a party, and one could never fail to be impressed by Senator Longmore's contribution. That sort of empathy, the charge to all of the other members to be clear and cognizant of the need to always understand the mental state, not just the mental state and the victim state, but to understand what it is like to be a whole person, and that we needed to approach it from that perspective. I want to congratulate her on this elevation, knowing full well that she will discharge her duties well, but with that element of compassion and empathy, which is so critical to these matters. She joins, Mr. President, a great pantheon of female leaders, because I also want to take the opportunity to recognize that Senator Kamala is not a senator anymore, right, Minister? She's no former senator. That former Senator Kamala Harris has now ascended to the leadership position, Vice President of the United States of America. And I'm sure that at the appropriate time, the acknowledgement will also come from the Minister of Foreign Affairs. But it is just that we see a shifting in leadership. We see a shifting in the sort of leadership that women bring to a situation. And I think it's a good week for that, your announcement. I congratulate her, Mr. President, and I thank you for the opportunity to say so on behalf of all of the opposition senators.
Mr. President, I just want to...
Thank you, Senator Scott Motley. Senator Dr. Longmore.
Thank you, Mr. President. I just wanted to show my appreciation for your extended congratulations. It is an honor to be serving in this role, and I only hope that I'm able to do as the task requires of me. And as always, I sincerely appreciate the support of my family here within this House and the staff that goes along with it. Thank you so much. Appreciate it.
Thank you. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following: Annual Report on Audited Financial Statements for the financial year 2019-2020 of the National Housing Trust. The third, Supplementary Estimates of Expenditure for the financial year 2020-21, and the National COVID-19 Vaccine Development and Vaccine Interim Plan.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 19th day of January 2021, a bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small, and medium-sized enterprises and for connected matters was passed in the House of Representatives with 6 amendments. I also have the honour to advise the Honourable Senate that on the 19th day of January 2021, the House of Representatives agreed to the Senate amendments to a bill shortly entitled the Dangerous Drugs Amendment Act 2021.
Mr. President, I signify my willingness to take charge of the bill, the former bill, in fact. I also beg to give notice of my intention at a later stage today to move for the suspension of standing orders to permit me to take second reading of the bill and to take it through its concluding stages.
Thank you, Madam Clerk. The bill to be read the first time, please.
A bill shortly entitled the Microcredit Act 2021, read the first time.
Petitions, papers, reports from committees, notices of motions given orally. Sorry.
Mr. President, I beg to give notice that at the next meeting of the Senate I will move, whereas Section 62 of the Electricity Act 2015 provides that the provisions of the Act shall be reviewed by a joint select committee of the Houses of Parliament 5 years from its date of commencement, and whereas the commencement date of the Act was December 22nd, 2015, be it resolved that, notwithstanding Standing Order 66.3, this Honourable Senate appoint a special select committee comprising the following members: Honourable Senator Orvin Hill, Honourable Senator Leslie Campbell, Senator Shireen Golding Campbell, Senator Damian Crawford, and Senator Janice Allen, to sit jointly with a similar committee appointed by the House of Representatives to review and report on the Electricity Act 2015. And Mr. President, may I further beg to give notice that at a later stage today I will ask for suspension of standing orders to allow me to take the motion, notice of which I've just given.
Thank you, Minister. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business.
Mr. President, I now move for suspension of the standing orders to allow me to take the motion, notice of which I gave earlier.
You should have heard the question. Those in favor? Against?
Mr. President, I ask that the motion be approved.
Members would have heard. Those in favor? Against?
Mr. President, I also now move for suspension of the standing orders to enable me to take second reading of the bill shortly entitled the Microcredit Act 2021 and to take it through all its concluding stages.
Those would have heard the question. Those in favor? Against? Minister?
Thank you, Mr. President. Mr. President, it is intended to proceed with this matter today, and I want to express appreciation to colleagues on both sides of this honourable chamber.
Okay.
Yes, Mr. President, to express appreciation to senators on both sides of this chamber for their understanding in respect of the timeline being pursued in respect of this bill. Mr. President, this government, led by Prime Minister Andrew Holness, has made it a priority to give and indeed to improve access to financing to all Jamaicans. All our policies which have sought to bring down interest rates and improve competition in the banking sector have in fact been about that very goal, and they continue to be about it, bringing down the cost of borrowing for Jamaican individuals and companies so they're better able to build, grow, and meet business, personal, or family goals. Members will recall, for example, policies which, among other positives, have allowed the Bank of Jamaica to bring down interest rates, which in turn allowed commercial banks to also lower their interest rates, the rates they charge to customers. Removing stamp duty, for example, on financial transactions allowed for individuals to move their mortgages from banks and allowed or prompted building societies and banks to bring down their interest rates in turn. However, as we are aware, many Jamaicans still do not access and cannot access financing from traditional banks and institutions because they are not able, generally to meet all the formal traditional requirements. And it was this gap in the market for loans and financial services that in fact created what we now refer to as the microcredit sector, the microcredit industry. So before us today is a bill to license and regulate microcredit institutions that provide financing to individuals and micro, small, and medium enterprises and for connected matters. This is indeed another initiative of this government to create more financial opportunities for our people and to protect citizens as they access those opportunities. Mr. President, the MSME sector plays a critical role in increasing economic growth and development in Jamaica. They make up approximately 98% of all classified taxpayers, and the government is determined to create the framework for solutions that help MSMEs overcome some of the challenges that hinder their growth and development. One fundamental challenge is, of course, access to credit, the ability to access credit. Without the ability to access credit, most businesses, large or small, cannot be competitive, cannot grow, and indeed, in some cases, especially in the earliest ones, stay afloat. So the credit market is, of course, made up of both large and small financial institutions, and large institutions tend to require more of their applicants for credit. And on the opposite end, small financial institutions operate with less information. They tend to, and this affects the risk balance. But, Mr. President, this government is determined, in line with Vision 2030, our national development plan, to facilitate the development of non-traditional financial options, such as microfinance. And this is as their processes and frameworks often aim to be less complex and more suitable for micro-enterprise and individuals who, as I indicated earlier, are unable to meet all the formal obligations of major commercial banks. The rapid expansion of the microcredit industry in Jamaica has given many low-income households, many micro and small businesses the opportunity to become a part of the financial system. But the industry has been largely unregulated and underdeveloped and in need of legal and regulatory reform. So as legislators, while we promote the growth of the industry, we must also protect their customers from predatory lending practices and also ensure, in our global environment, ensure that microcredit institutions are not used to facilitate money laundering and terrorist financing. So these are clear objectives of the bill and manifest themselves throughout. This act, which formalizes the microcredit industry through licensing and regulation, is timely in light of recent developments pertaining to the issue of de-risking and the resultant closure of bank accounts by some commercial banks, which has implications for the microcredit industry. So we're strengthening the whole ecosystem that addresses some of the deficiencies which have caused the challenges in correspondent banking relationships, which in turn will help allow access to correspondent banking relationships as well. So it's strengthening the system as a whole. And of course, this Honourable Chamber had already heard me explain that Jamaica recently had successfully been upgraded in several aspects of our FATF classification, and the Minister of Finance gave further details on that process on Tuesday just past. So the passage of this bill is also one of the priority legislative reforms necessary for Jamaica to remain in compliance with the FATF and CFATF procedures required to improve our anti-money laundering and CTF framework. It is in fact imperative that the Microcredit Act come into force before the end of January 2021. This is part of the action plan which has been shared publicly by the Minister of Finance from last year, when it was, of course, announced that Jamaica's grading was affected because of the state of our framework, as at 2015, reported on in 2017, and then further changes in the framework, which, of course, based on the size of our economy, placed us into another category, which again changed our assessment profile. So an action plan was defined, determined, and agreed and communicated to FATF, and we are now making best efforts to ensure that we start 2021 on the best foot forward, coming out of the last assessment session, and that requires us to pass this bill today. Mr. President, the bill was previously, or rather a microcredit bill, was previously tabled in that other place in February 2019. It was withdrawn, significant consultations held with the industry, players, associations, technical advisors, and indeed significant work has been done to address the concerns that were raised by the industry, while of course retaining some of the elements of consumer protection and CTF and AML management, which are required and which in fact make this bill an imperative. The bill in that other place on Tuesday was passed with 6 amendments. I had asked the Parliament to circulate the amendments, and they were circulated unusually because, of course, normally when the bill is tabled here, we take the bill as amended, which we are. But I knew that because we had asked senators to review the bill as tabled in the lower house, that those who were pursuing that exercise would certainly benefit from visibility of the bill, the amendments done in the lower house. So those were circulated, and I will again, for ease of reference, point them out as we go through the bill. Before us today is also, however, a list of amendments to be moved today. And again, this is one of the reasons why it's important for us to pass today, because these amendments will need to go back to that other place in order for them to be accepted. If we were to wait until the following week, then, of course, we would miss the January deadline. I can also advise as well that I believe next Friday is Cabinet Budget Retreat, so the Senate may not sit. But that is for another discussion on housekeeping a bit later. So again, in respect of this list of amendments which has been circulated today, I will point these out as we go through the clause by clause. Mr. President, the first, yes, they're circulated. That's what you have there. The list of amendments, that's what you have. Yes. The ones that were tabled in the House were circulated by email. So I will point them out to you. It's not many, and they're not, while it's 6, it includes things like renumber item 16 as 17. So, you know, they count each one. So, Mr. President, we start as always with clause 2, which deals with interpretation. And I would indicate, of course, that the principal definitions, microcredit institution and microcredit service, set the context for this bill. So a microcredit institution is defined as a company licensed under this Act to provide a microcredit service to individuals or MSMEs or both. And the definition of microcredit service is one of those amendments that were taken in the lower house, where the words provided by a microcredit institution were deleted. And the definition which remains is therefore that microcredit service means any one or more of the following services. 1, the granting of credit facilities to individuals or MSMEs or both. And 2, the provision of business advisory services, not including the advice relating to the financial services regulated by the FSC, by the Financial Services Commission, to individuals or MSMEs or both. So the definition of microcredit service now fits more seamlessly with microcredit institution. The additional words had created a bit of circularity that was perceived in the lower house and in fact discussed between the Leader of the Opposition and Minister Clark, and that was agreed. That amendment was agreed to. Microcredit service definition continues in paragraph B to say, any other activity designated by the supervisor as a microcredit service and approved by the Minister by order subject to affirmative resolution. So any other activity would come back to this House, it would come back to both Houses for agreement. And of course, we indicate that the supervisor is the Bank of Jamaica, who operates as the supervisor in respect of banking services generally. So we're ensuring that there's institutional synergy and cohesion, and that we are not creating additional weight on the government structure. Mr. President, to clarify that microcredit services do not include receiving deposits from the public or banking business within the meaning of the Banking Services Act. Mr. President, an amendment that's being proposed today, again in Clause 2, is to the definition of the word spouse. And essentially what will happen in that definition is that the words, sorry, I'm just going to, there's always a simple way and a complex way. If you have a look at page 7, the words "and for the purpose" will be deleted from the closing words of the definition. So I'm going to read what is on the amendment list, which says in the definition of the word spouse, delete the words "at the date and for the purposes of a determination of a connection with a licensee pursuant to subsection 4H, and substitute the words therefore at the date of a determination of a connection with a licensee pursuant to subsection 4H. So essentially, the words "and for the purposes" have been lifted as they were seen as not making the definition as clear as it could be. So that has been removed, and that is one of the amendments to be proposed today. Mr. President, Clause 3 speaks to the areas, seeks the transactions, persons and entities that are not to be covered by the microcredit bill. Now, these specific circumstances are actually listed in the 3rd schedule, and they include financial institutions that are regulated by the Bank of Jamaica, Financial Services Commission, or other regulatory bodies, as well as credit facilities offered to high net worth individuals and by employers to their employees. Now, that last category, transactions, loans between employers and their employees, was an amendment taken in that other place on Tuesday. It was in fact a proposal that was put forward as well by the opposition, and that has been included in the bill. So essentially, the word at the end of the word "and" at the end of item 15 in the 3rd schedule was deleted. Item 16 was renumbered as item 17, and the new item 15 inserted in the 3rd schedule now reads: the provision of credit facilities by an employer to an employee or to a person in the full-time service of the employer. So this is, of course, to facilitate schemes which exist within companies where employers lend to employees. They have rotating funds and revolving loan schemes which allow employees to access credit at perhaps a lower and certainly less complicated system than they would if they went to an external bank. So it's preserving that mechanism. What we wouldn't want is for companies offering a service to their employees to be captured by this, the need to now be regulated as a microfinance institution. That was never the intention. Mr. President, Part 2 of the bill starts with Clause 4, and it in fact deals with the functions of the regulatory authority. As indicated, it's proposed to be the Bank of Jamaica, and the functions of the regulatory authority will be executed through the supervisor and supervisory department. These include formulating procedures for the licensing and regulation of microcredit institutions, the developing of standards of practice and codes of conduct and guidance for the general operation of licensees, including credit administration, transparent lending practices, reporting requirements, monitoring licensees on an ongoing basis by off-site and on-site examination for compliance with the Act, and of course based on the risk profile of licensees, prescribing the type of returns and other information that licensees are required to file with the supervisor, advising the Minister on matters of general policy relating to microcredit institutions, and imposing sanctions for the identified breaches of the provisions of the Act and regulations. The regulatory authority, Mr. President, is also required to submit to Parliament through the Minister an annual report relating to the execution of its functions. Clause 7 speaks to cooperation of the regulatory authority with other regulators, both local and foreign law enforcement authorities and other regulatory counterparts, to facilitate information sharing and other forms of cooperation and collaboration. This is, of course, done within the existing legal framework and is, of course, relevant to the matters raised earlier regarding counterfinancing terrorism and anti-money laundering regulations. Clause 7 also makes provision for the cooperation and collaboration between the regulatory authority and the Consumer Affairs Commission in relation to the investigation of any apparent contravention of the Act. And based on the subject matter of the complaint, either body may refer a complaint to the other as appropriate. So that ensures that wherever the citizen goes with their complaint, that they are guaranteed, that they won't be told, no, this is not the place to report, you must report to X. It is that both the, either the regulatory authority or the Consumer Affairs Commission can work with the other to ensure that the citizen's complaint is appropriately addressed. Mr. President, Clause 8 is, reflects another one of the amendments made in that other place. Clause 8, in fact, was previously entitled Ministerial Directions, and what it included was the ordinary clause that is usually referenced in legislation regarding the giving of general policy directions. But it was felt that it was not appropriate for this particular framework, and what is now reflected in the bill passed in the lower house is a marginal note which states consultations relating to the national interest, and the amended clause now reads, in making a determination on license approvals or revocation, the supervisor shall consult with the minister on matters relating to national interest. Because it was felt that really this regulation is not the type of regulation, especially moving into greater independence as we will, for the minister to be giving general directions on a consistent basis. And this was therefore agreed to be a more appropriate scoping of the consultation as between the supervisor and the minister. Mr. President, Part 3 starts with Clause 9, and the first clause deals with the requirement that of a person to obtain a license in order to provide microcredit service. So this clause is a clause which deals with the requirement of a license and making it an offense to operate a microcredit service without a license. It expressly states, Mr. President, that a contract that is made by a person who is not licensed to be a microcredit institution to be unenforceable. And Mr. President, the fine provided for here is actually one of the amendments that we will meet when we reach the fourth schedule, because there's been an adjustment to ensure that it is more appropriately juxtaposed with the offense of not displaying your license. The fines were a little dissonant, and they have been corrected in the amendment to be proposed later today. Clause 10 sets out the procedure for obtaining a license, and the applicant is required to apply to the supervisor in accordance with the prescribed rules made under the Act. And the clause also makes provision for the supervisor to grant or refuse to grant a license to the applicant. Further, where the applicant is refused a license, the applicant is given the opportunity to be heard by the supervisor. Clause 11 deals with the conditions of the license, and it requires the licensee to pay a prescribed license fee to the Accountant General on the initial grant of the license and thereafter annually. The licensee is also required to commence operation within 1 year of the grant of the license or such longer period as allowed. Mr. President, Clause 12 mandates that the licensee should prominently display its license at its principal office and at each branch, and that is the other fine which will be addressed, looked at in Clause 14. In the fourth schedule. It won't be addressed, it won't be changed, but it is the comparison that you will consider. Clause 13 prohibits a licensee from transferring or assigning its license, and it also prohibits a licensee from causing or permitting another person to use its license. Where the licensee causes or permits another person to use its license, the supervisor may in fact suspend the license. Clause 14 sets out the procedure for the replacement of a license that becomes lost, defaced, or destroyed, and the licensee will be required to pay a replacement fee to the Accountant General for a substitute license. And this now is the next amendment, and it may be found at page 16. It is an adjustment to subclause 4, so 14.4. And essentially, what has been done is that the requirement to republish or to publish the replacement license is not necessary, because it will simply replace what was already published. So it's removing some of the bureaucracy from what was a process intended to ensure that the licensee is in fact not only properly licensed, but displaying their license appropriately. So the amendment there would be reflected as the deletion of sub B and the appropriate adjustment. So I will read the full amendment. The formal amendment is that we will delete subclause 4 and substitute, therefore, the following. A license that is substituted pursuant to subsection 1 shall reflect the information that was specified on the original license. So the remaining part has been struck. Mr. President, Clause 15 criminalizes obtaining a license by false representation. Clause 16 criminalizes engaging in false or misleading advertising that falsely implies or explicitly states that the person is licensed under the Act as a microcredit institution. Again, this is signaling the level of protection that we want to be offered to the public, signaling how serious we think it is for a company or person rather to represent itself as a licensed microcredit institution, providing services that are being properly supervised and properly regulated when this is not the case. We want people to know that when they go to a microcredit institution, it's one that's being supervised and regulated in their interest. Clause 17, Mr. President, is intended to address the use of words or titles that represent or imply that a person is licensed to operate as a microcredit institution when it is in fact not. And it is not intended to disenfranchise genuine cases, so bodies established, for example, to represent the interests of the sector, so advocacy organizations. So Clause 17 prohibits a person who is not licensed under the Act from using any name, title, word that implies that it's licensed to provide the microcredit service, except with the approval of the supervisor, or if it is an association representing microcredit institutions, or where it forms a part of the name of the individual or the place. Clause 18, Mr. President, requires a microcredit institution to obtain approval from the regulatory authority for changes in its corporate structure, such as mergers, amalgamations, acquisitions, and transfers. The application should be in form of a scheme, and a merger, amalgamation, acquisition, or transfer, which is effected without the approval of the supervisor, shall be void. And here, Mr. President, this also ties in with the earlier issue regarding transferability of licenses. It's made express in this clause that they will have to get a new license. It will not be that they simply merge and take on a license of one of the parties. Clause 19 addresses the matter of transactions or arrangements that have the effect of changing the effective control or substantial ownership of the licensee. Accordingly, Clause 19 requires a person who proposes to enter into an agreement or an arrangement to acquire the shares of a licensee and who would become a substantial shareholder of the licensee to obtain prior approval of the regulatory authority in respect of the agreement or arrangement. And in determining whether or not to approve an application, the supervisor shall take into account such matters as the nature, source, and sufficiency of the applicant's financial resources, business record and experience of the applicant, and whether the applicant meets the fit and proper criteria. Of course, as this part feeds into the whole ecosystem which I spoke about earlier. An acquisition of shares effected in contravention of this section, Mr. President, will be void. And the clause also specifies the circumstances and actions that can be taken in respect to the shares acquired in contravention of this section. Clause 21 imposes an obligation on the licensee to notify the supervisor of matters that could adversely impact it, such as any fraud or other criminal activity committed by or against the licensee, any dismissal or resignation of an officer, any circumstance which renders a substantial shareholder or officer of the licensee incapable of satisfying the requirements of a fit and proper person, any acquisition of 10% or more of the issued voting share capital of a licensee, and again, for example, if proceedings for compulsory winding up of the licensee have commenced, or the licensee has been served with a notice for the commencement of compulsory winding up of its business, these are matters which must be notified to the supervisor. And again, for clarity, it is because it is in the interest of the clients and customers of these entities and the supervisor's interest in ensuring that their concerns are always taken into consideration. Clause 22, Mr. President, imposes a restriction on a licensee making an alteration to any of its incorporating documents unless it notifies the supervisor and the supervisor does not object. Any alteration made to the incorporating documents of the licensee that is incorporated in Jamaica in contravention of this section, again, shall also be void. Clause 23 imposes a restriction on a licensee changing its registered name unless it notifies the supervisor and the supervisor has no objection, and the supervisor shall reissue the license in the new registered name of the licensee once the relevant conditions have been satisfied, including surrendering the existing license and paying the requisite fee. So again, because there are restrictions in respect of naming, etc., this is a reasonable extension of the obligations in that regard. Clause 24 allows an authorized officer at all reasonable times and as may reasonably be required for the performance of its functions to have access to all documents in the possession or control of the licensee and, where applicable, take copies of such documents. Also, Clause 24 requires any officer, employee, or external auditor of the licensee to furnish such information or to produce such documents as are in its possession or control that relate to the operations of the licensee. Clause 25 outlines a range of measures that the supervisor may employ for breaches of the provisions of the Act, including issuing a warning to the licensee, directing the licensee to cease such practice, directing the licensee to take corrective action, suspension or revocation of the license, and such matters. And Mr. President, so we're going through a bit in detail because it is that we want to ensure that senators who have reviewed or who have not had the opportunity to review are able to walk through the bill with us, given our intentions today. Clause 26 and Clause 27 deal with suspension and revocation. Clause 26 sets out the circumstances for suspension of the license, including the licensee intends to suspend microcredit service for a period for whatever reason. A substantial shareholder or an officer has been charged with an offense involving fraud or dishonesty. The licensee is contravening the Act or regulations by engaging in an activity which doesn't constitute a microcredit service without instituting the differentiating measures referred to in Section 31. We'll soon come to those. Failing to keep accurate records in respect of the microcredit business, failing or refusing to file the requisite returns, causing or permitting another person to use its license, or breaching a supervisory direction. And again, all of these are ultimately about consumer protection, because if it is that measures need to be put in place to protect customers from the impact of the underlying issue of the contravention of the Act, then it must be that, that the supervisor is able to take immediate action, whether temporary or otherwise. So the circumstances for revocation are set out in Clause 27, and they include the licensee operating in breach of its incorporating documents, in breach of its license, it's failed to commence operations within the period specified, proceedings have commenced for the voluntary or compulsory winding up of the licensee, and where it has ceased to be viable. The licensee will be given an opportunity to be heard and to make an objection to the supervisor in relation to either the suspension or revocation of a license within a specified time frame. The clause, therefore, also gives the supervisor discretion that where the supervisor intends to suspend or revoke a license, then the supervisor may take such action as is necessary to safeguard the security and confidentiality of the credit and other personal information and documents in the possession and under the control of the licensee, again, protecting the consumer. Part 4, Mr. President, deals with issues of governance of the licensees. 28 deals with the requirement to have a board of directors with requisite knowledge and skills, expertise. 29 deals with the responsibilities of the board for effective governance of the institution. And 30 deals with the duty of the licensee to ensure that each substantial shareholder and officer remains a fit and proper person. Part 5, Mr. President, deals with the limitation on business activities of the licensees and obligations of the licensees as follows. Clause 31, Mr. President, provides for microcredit services not to be commingled with other business activities. So it might be of interest, Mr. President, the bill that was tabled in February 2019, it restricted microcredit institutions from engaging in any service other than microcredit service. So if you're a company doing microcredit, you couldn't do anything else. And it was, of course, a concern raised by the industry, and it has been met. So essentially, that restriction is no longer in place. It's not contained in this bill. But what is in place is a requirement in respect of separate accounting and separate business arrangements, because it must be that you are able to demonstrate your compliance with the obligations and the regulatory framework of the supervisor. And certainly if your accounts are mixed in with unrelated services, this could, of course, obfuscate the method by which you are running your business. So the issue is about now accounting methodology and not about restricting the structure that you have, the corporate structure that you may have for your business. So, Mr. President, the requirements are therefore that separate bank accounts are kept and separate accounting procedures and accounting records are kept. So Clause 32, Mr. President, deals with foreign currency, and it actually prohibits dealings by a licensee in a foreign currency unless it has the requisite authorization by the Bank of Jamaica. So because you're microcredit regulated by BOJ doesn't mean that you're automatically able to deal in foreign exchange. You must have the requisite authorization from the BOJ to deal in foreign currency. Clause 33 deals with the matter of confidentiality, and it requires every officer, employee, auditor, or agent of a microcredit institution to treat information and documents pertaining to its customers in the performance of their duties as confidential. And the obligation extends beyond termination of duty or employment with the licensee. Also, persons are expected to treat all information received confidential. The bill specifies the circumstances under which information can be disclosed, including, as would be reasonable, that is the written consent of the borrower, and of course pursuant to a court order. Records to be kept by the licensee are treated with by Clause 34. The clause requires microcredit institutions to maintain proper records for at least 7 years, and the clause also requires them to furnish their records in the prescribed form and manner. Clause 35 requires a licensee to be audited annually by an external auditor who's a registered public accountant. And where a licensee meets the description of a small company, Mr. President, then, and it's a small company under the Companies Act, it shall have its accounts prepared pursuant to the Companies Act by an external auditor who is registered as a public accountant. Clause 38 deals with the presentation of financial statements. Clause 38 deals with the presentation of financial statements. And again, the bill that was tabled in February 2019 required them to submit audited financial statements or accounts prepared pursuant to the Companies Act within 90 days. But based on concerns raised by the industry, the bill has been revised to increase the timeline to 120 days for smaller institutions, to give them more time to be able to do what is necessary. So it is to not make it impossible to comply. It is to ensure that the rules permit compliance and then to enforce. Mr. President, Part 6 deals with appeals to the tribunal, as an appeal tribunal is established under the bill. Clause 41 deals with this particular issue of the Supervisory Appeals Board. Again, of interest, the bill that was tabled in February 2019 made provision for an aggrieved persons to appeal to the Supervisory Appeals Board under the Banking Services Act in relation to fit and proper issues, objection to appointment of an external auditor, and revocation of a license. But based on concerns raised by stakeholders during consultation, Clause 41 has been revised to altogether remove the provisions relating to appealing the supervisor determinations, so decision not to grant a license or decision to suspend or revoke, since it would pose challenges with how a regulator would effectively supervise the entities. Persons will still have the right to appeal those decisions by using the court, of course. In addition, Clause 41 has been revised to replace the Supervisory Appeals Board, with a specially established Microcredit Appeals Tribunal. So matters relating to fit and proper issues and objection to the appointment of an external auditor will only be appealable to this tribunal, the Microcredit Appeals Tribunal. And the constitution and procedures of the tribunal are addressed in the second schedule. Part 7 now deals with the express consumer protection matters. And again, it should be noted that the Consumer Affairs Commission will be responsible for market conduct matters, particularly where a complaint involves a matter of consumer protection, which ordinarily requires powers to, among other things, assess and determine the fairness of contract terms, to impose obligations, or to take actions designed to provide redress to the aggrieved consumer, as these are not powers that exist within the Bank of Jamaica. So, however, where a complaint involves the matter of a licensee breaching its statutory obligations or breaching a requirement of the framework, the imposition of regulatory sanctions is a response that can be made by the Bank of Jamaica. And I started to speak to this synergy between the two institutions earlier. To avoid overlap in responsibilities, provision is included in the Act to ensure that the cooperation and collaboration between the Commission and the regulatory authority include the referral of matters to each other where appropriate. So Clause 42 speaks to the power of the Consumer Affairs Commission to investigate complaints brought to it by a consumer of a microcredit institution, and 43 specifies that where the licensee grants a loan, the licensee shall provide a copy of the loan agreement to the consumer, and the loan agreement should include information such as particulars of the parties, date of the loan, date the loan is made and dispersed, amount of the loan, and the terms of its repayment, including full disclosure of the cost of the loan expressed in percentage, rate of interest, and dollar values, the security for the loan required, if any, fees and charges, if any, fact sheet containing key terms of the loan agreement. And this clause is intended to promote transparency through the requirement that there must be full disclosure to clients of all terms and conditions regarding the services offered by the microcredit institution. This is a key provision of this bill in terms of consumer protection. Too many times there are stories of persons who enter into loan arrangements in situations of urgency and they do not fully understand the terms to which they are committing. It results in default, it results in personal embarrassment, and it often results in a cycle of indebtedness from which they cannot emerge. Information is king, Mr. President, and this is something that we as an administration recognize. It is something that this bill embodies. Consumer protection must be founded on a platform of information, and this clause is therefore very important here. So, Mr. President, Clause 44 requires the licensee to provide a printed copy of a statement of accounts at the request of a borrower. So if a borrower wants to see what their account looks like, they must be provided with a statement of account. And the option can request, of course, in electronic form. For efficiency, you want to provide options. It also stipulates that the licensee shall issue a receipt or written confirmation of the repayment of the loan to the borrower. Again, the need for this is crystal clear, because the unscrupulous people who prey on persons who, especially in their situation of distress, but sometimes also just not sufficiently organized to make sure they keep records of everything in respect of their loan. This is now placing an obligation. They must get a receipt when they have paid. They must get a statement when they need to track how their loan is going. And again, these are important elements of consumer protection. So Clause 45 imposes the obligation to provide evidence of the borrower to repay the loan. And this encourages responsible lending and reduces the risk of over-indebtedness of borrowers. So it is, this is a bit of a challenging provision, but it is one which recognizes the situation which exists in Jamaica. And I think anyone who listened to the debate on Tuesday in that other place that heard of so many persons in circumstances where they overcommitted because they were they either did not understand what it would take, what it would cost, or went into circumstances which they would never have been able to emerge from. So this means obligations on both the borrower and the lender side, and it's important for us in this general scheme. The matter of the interest rate, Mr. President, Clause 46, this is something of great public interest and of course of interest to the stakeholders. The bill that was tabled in 2019, it had required microcredit institutions to determine their interest rate by taking into consideration cost of funds, profit margin, borrower's credit risk, administrative costs, other loan-related costs, and the interest rate was to be linked to the short-term Treasury bill rate. Very prescriptive, Mr. President, and of course, in a free market economy and being a government that encourages free market operations and principles, we responded positively to objections raised by the industry in respect of this matter. So the bill has been revised to allow for flexibility in the determination of interest rates charged. So Clause 46 now allows institutions to determine their interest rates based on market forces and their own risk assessment. I know that there have been discussions about whether there should be capped interest rates, and again, that would be another way of imposing the same restrictions that would have been in the 2019 bill, which is instead of informing consumers, helping them to make better decisions, so that if one microcredit institution is not giving you the appropriate information, you're not comfortable in understanding not only what the loan is going to cost you, but how you're going to repay, that this is maybe reason for you to go to another institution and see what they have on offer, so that you can find a solution that is better for you. And I want to say that there are close to 200 microcredit institutions operating now. They operate all across the island. And there are options, persons have options, and perhaps even with this regulation, which will now ensure that unscrupulous persons who enter this industry with only an intention to exploit, and which they're unable to do with new regulation, perhaps they will fall out of the market, leaving better service providers to our people in Jamaica, making sure that they are able to safely access credit in protection of their interests. Mr. President, I just want to add as well that Clause 46 was revised to require microcredit institutions to provide their customers with information on the effective annual interest rate. And that is the interest rate that covers all their financial costs, interest rates, fees, and commissions. Because you don't want to hear, okay, the interest rate is X, and you say, I can definitely afford this. You sign up for the loan, and then you are told, oh yes, but there's this fee, and there's this commission, and then there's this charge. And all of a sudden, what was a solution to your problems has now become a problem in and of itself. So a loan for the loan, exactly. So this is expected to facilitate greater transparency, as consumers will be able to comparison shop for loans, stimulating competition based on service, based on availability, based on the positive aspects of access to financing. And again, the methodology for determining the effective annual interest rate is found in the first schedule. So, Mr. President, just on the point of this clause, I really want to encourage Jamaicans who are listening, explore your options. When this bill is passed, this bill is going to seek to ensure that you are protected, that as a consumer, you are protected. You can shop around. When the man folds his arms and says, well, you don't have to take the loan, don't feel intimidated and feel that this means that then you must say, no, 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 I need it. Say, okay, I'm going to go home and think about it. And then maybe go down the road and see whether someone else has something else on offer that will not require you to be in a cycle of indebtedness forever. So shop around, be informed, and know that this government is seeking to protect your interests. Mr. President, Clause 48 sets out the procedures for making and resolving consumer-related complaints relating to consumer protection under the Microcredit Act, and the responsibilities and powers of the Consumer Affairs Commission in investigating and resolving those complaints. So Clause 48 supplements the relevant sections of the Consumer Protection Act. And I just want to indicate that Clause 48 sub 4C was amended in that other place by deleting the words after giving the licensee reasonable notice. This is the provision that, that actually deals with the circumstances where a warrant has been issued, and it was felt that in the normal operation of the issuance of warrants, notice is not required on top of that, and therefore it seemed to be a gold plating and has been adjusted to make the situation one more appropriate for the circumstances.
Minister. The minister's time for speaking has expired.
It went so fast. The minister's time having expired, may she be allowed enough time to continue with her presentation.
The question is that the minister's time be extended to allow her to complete the presentation.
Thank you, colleagues, and thank you, Mr. President. And again, we're going through in some detail because of the tight timeline that we're taking, so we're making sure everyone is aware of the provisions of this bill. Mr. President, Clause 49 deals with the Code of Conduct. So the Code is intended to establish minimum standards of good practice required by licensees towards their consumers, their customers. Accordingly, it makes provision for the CAC, the Consumer Affairs Commission, with the approval of the Minister, to make and issue a Code of Conduct for microcredit institutions on consumer-related matters. Further, the Commission is empowered to issue directions to a licensee who contravenes the Code of Conduct. It will promote fair treatment of the consumer by the licensee and, for example, this is where they may place the obligation as well to present the loan agreement in plain and simple language that is understood by the client. Mr. President, Clause 50 empowers the Commission with the requisite enforcement powers to effectively execute its functions under the Microcredit Act. 51 now moves into false and misleading advertising by the licensee in relation to the grant of a loan, which speaks for itself. And Clause 52 prohibits the use of misleading, false, or deceptive information to induce a person to take a loan from a microcredit institution. Clause 53 speaks to the issue of threatening borrowers. Mr. President, the bill that was tabled in February 2019 criminalized a person who, in an attempt to recover a debt, displays or causes to be displayed or uses any threatening, abusive, harassing, or intimidating words, behavior, writing, sign, or visible representation to a person who borrows money from the licensee. But the phrase was too broad, Mr. President, and indeed the administration has again listened to the stakeholders, and the bill has been revised, because really, if you threaten suit, that is indeed a threat under what was the previous language, and that could never be the intention. So the bill has been revised, and Clause 53 now restricts its application to the use of violence or other criminal means to harm the physical person or property of the person, since there are, in fact, other pieces of legislation, including the Cybercrimes Act, which addresses some of the issues that might be of concern. No, already. I was just speaking about that was between 2019 and the one that was tabled in the lower house. Yes. Yeah. Part 8, Mr. President, and we're getting there now. Part 8, Clause 54 deals with the winding up of licensees. It speaks to the procedure for voluntary and compulsory winding up. Of course, in general, winding up shall be subject to the Insolvency Act unless the licensee is part of a financial group under the Banking Services Act, in which case the Insolvency Act will only apply to the winding up of that licensee with the written consent of the supervisor. So building in some flexibility, but recognizing the structure of the sector as it exists. Part 9 deals with general matters. 56 speaks to fixed penalties, so it makes provision for persons who commit less egregious offences to discharge liability conviction of such offence by payment of a fixed penalty. And these offences are set out in the 5th schedule. 57 speaks to search warrants in respect of contraventions of this act. So it allows an authorized officer under specified conditions to apply to a JP for a warrant to enter and search the premises of a person who is suspected of committing an offence under the act, which is a clause that is to be found in other legislation as well. The authorized officer, as is usual in these circumstances, is also empowered to seize and detain any relevant documentation, that is documentation relevant to the investigation. Part 10 deals with miscellaneous matters. 58 speaks to the regulation-making power of the authority, and this exists with the approval of the minister in writing. And regulations may relate to the requirements for grant of a license under the Act, license fees and other matters in respect of which fees are to be payable and the amount of such fees, mergers, amalgamations, acquisitions, transfers, and sale of a licensee and the establishment of branches. Mr. President, regulations under this clause shall be subject to affirmative resolution, so they'll come back. Power of regulatory authority to make rules is provided for under Clause 59, and here again, this is where rules may be made by the regulatory authority with the approval of the minister, and this section now deals with governance of the licensees, forms for applications and notices, AML and CFT, and prevention of proliferation of weapons of mass destruction, rules regarding the preparation and presentation of returns and other reporting requirements, as well as the manner of filing such returns and other information. These rules also subject to affirmative. Mr. President, Clause 61 deals with the statutory protection for authorized officers of the BOJ exercising their function in good faith, and statutory protection is also extended to the officers of the Consumer Affairs in the same way. Clause 62 makes provision for the review of the Act to be conducted no later than 5 years after the commencement date by the usual Joint Select Committee. And importantly, this provision will also facilitate the collection of data over the first 5 years of its operation, which may enhance the regulation in the next phase. Mr. President, Clause 64 deals with transitional circumstances. So it provides for a person who at the date of commencement of the Act is operating in a business which falls within the criteria set out for a microcredit institution. It provides a period of 12 months for them from the commencement date to apply to the supervisor for a license. In addition, to operate under this Act, in addition, a person who at the commencement date is operating a business which falls under it, under this regime, together with another type of business, shall within 12 months of the commencement date separate the businesses and apply to the supervisor for a license to continue to operate as a microcredit business. So it's providing for existing business to have a year to bring themselves into line, which is a more than reasonable provision. Mr. President, the savings clause is found in 65, which provides for the preservation of money lending transactions which were entered into before the commencement date of the Act. So they will continue to be enforceable after the commencement date. And this is, of course, to preserve what exists. If persons have taken out loans, you know, they couldn't wake up tomorrow morning and find out that all of a sudden there's no loan and the business has no business. It would be an unthinkable result. So those are being quite clearly preserved, expressly preserved. Mr. President, the first schedule of this Act is divided into two parts. Part A deals with methodology for determining the effective annual interest rate. Part B provides for the categorization of MSMEs based on the MSME and entrepreneurship policy, which have been tailored, however, for the purposes of this Act. So MSMEs under this Act will only be defined in terms of their total annual sales of enterprise, not by number of employees, etc., because they're going to have their own structures and sizes based on how they operate. The second schedule provides for the constitution and procedures of the Microcredit Appeals Tribunal. The third schedule is divided into two parts. Part A, dealing with the list of transactions, persons, and entities not regulated by the Act. So I spoke to those earlier, where we had inserted the new Item 15 in relation to employment loan schemes. And Part B stipulates that the provision of a credit facility to a high net worth individual will now constitute a microcredit service, and as such would provide for high net worth individuals to be exempt from the Act. Mr. President, it should be noted that by way of a motion, that's not necessary. Fourth schedule, Mr. President, lists the offences and penalties relating to contraventions of the provisions of this Act. And this is the final amendment that has been, that is reflected on the list provided before you, and it can be found on page 71 of your bill. So in the third column, in relation to the penalties for the offence under section 9.2, in paragraph A, we will delete the words $1 million and replace the words no, the short form. It is in the fourth schedule. Look for section 9.2. It should be fairly early in the schedule. Look for the offence under section 9.2 in the third column. Let me find it on my long form. Found it? Okay, great. I was just going to look in my long form. We're deleting $1 million and replacing it with $2 million. And in paragraph B, replacing $500,000 and substituting, therefore, $1 million. And this, when you compare it to the reference in the fourth schedule, just another page on, in relation to clause 12, which is where you deal with the offense of failure to prominently display your license at your headquarters and in any branch. There you'll find that the penalty is $1.5 million. So it was noted that the fine for having a license was in fact less than the fine for not displaying the license. So that has been adjusted appropriately, I would say. Mr. President, in fact, I want to, well, the fifth schedule lists offences in respect of which liability to conviction may be discharged by payment of a fixed penalty, and the sixth schedule lists consequential amendments to various acts, including the Credit Reporting Act, the Money Lending Act, Proceeds of Crime Act, Terrorism Prevention Act, and the UN Security Council Resolution Implementation Act, the amendment of the POCA and the TPA, the Proceeds of Crime Act and the Terrorism Prevention Act, will ensure that the licensed microcredit institutions under the Microcredit Act are recognized as financial institutions. So it will bring them into the AML-CFT requirements under those acts. And it's important to note that the Money Lending Act will continue to exist and will apply to unregulated loans offered on a non-commercial basis, such as money lending transactions between two persons who don't lend on a day-to-day business. So would say the good Mr. Bunting were to see it in his heart to help me out if I fell on hard times, it would not mean that he would now automatically personally be regulated as a business. He would just indeed be being a good friend. So, and you notice I didn't use any other references, just one of kindness. So, Mr. President, this is intended to strike a balance between recognizing what is actually legitimate money lending that does not require and would not appropriately be regulated under this regime, but ensuring that we catch everything else. Mr. President, it is indeed hoped and it is expected that enactment of this bill will assist in formalizing the operations of money lending institutions, improving the environment for the sector's development, providing measures for the protection of consumers and protecting the industry against the risk of money laundering, because it is when the industry is viewed as a risk that they start to have difficulties in operations. The stronger regulation is, the more likely they are to have ease of operation. And it's also expected that the enactment of this bill will assist the industry in mobilizing resources for micro and small-sized enterprises, hence creating jobs and contributing to the economic growth of the country. Mr. President, I look forward to today's debate, and I thank members in advance for their support. I thank you.
Senator Bunting.
Thank you, Mr. President, and thank the Minister for detailed, more than usual detail in going through. I think it was helpful and it is appreciated. Nevertheless, Mr. President, the fact that we have a bill of this length, on the long form it's 88 pages. On the short form it's 90 odd. To go through and take through all of its stages in one day is a bit unreasonable to ask the members. I've spent some time myself. I tried to, as a courtesy from last week, I took a copy of the long form of the bid, even though it hadn't been formally tabled. And I've been spending some time going through it. And notwithstanding having some experience in the financial sector, it's not the type of bill that you can just go through quickly. It's unfortunate that we once again find ourselves rushing to meet an externally imposed deadline. And one, quite frankly, that in any event we would have known about for some time. It would not have surprised us. The truth is that this is not the first time, and I'm sure the leader of government business will say, well, you know, it has happened from previous administrations. But the truth is, it doesn't mean that because we have operated suboptimally before, that is how we should continue. So I really want to urge, Mr. President, that the government provides for a little more notice, a little better planning, so that the Senate can afford to deliberate on bills and, play a valuable role in reviewing the legislation that comes from the lower house. Having said that, I want to really look on the bill itself, and before diving into the particular clauses, look at the sort of scheme of the bill, because I always find it helpful if you look at what the objective of a bill is and the framework that it provides to achieve those objectives. And I believe the minister spoke to the bill being developmental. It may not have been a word she used, but it provides for the development of the microcredit sector. And the truth is, the sector themselves have complained that this bill is not developmental, but in fact is penal or punitive and will not benefit the sector. The truth probably lies somewhere in between. And as I go into describing the arrangement, I hope it will become clearer what I mean. So, the bill intends to regulate microcredit services through the supervision of microcredit institutions. And there is really three structures that it utilizes to accomplish this. The first is what is called a regulatory authority, the Bank of Jamaica. And they will provide a sort of standard prudential type regulation that you would, that they provide for many other financial institutions, cambios, etc. This is the element of the bill that is creating the urgency for passage today. This is what we need to pass to comply with the Financial Action Task Force commitments. We know the disadvantage we would be put at if we were to be blacklisted or come under further, prejudicial oversight from the EU and some of these other jurisdictions. So we understand that that is what is creating the urgency. They want to ensure that these institutions are not used to facilitate money laundering, terrorism, financing, or any of those criminal activities. So that is one division, so to speak, of what this bill is trying to achieve and the institution that does it. The second, though, which is treated with, particularly in Part 7 of the bill, is the consumer protection element. It is strong on consumer protection, and it identifies the Consumer Affairs Commission as the agency that will enforce those components. Now, while nobody could be against that, and I think we're all in favor of that, the challenge I have with this bill is that we're applying it only to microcredit institutions registered as such. But the microcredit services are provided by a whole range of other institutions who will get no protection, who will get no consumer protection. For example, Mr. Speaker, hire purchase companies. Hire purchase companies. I recall early in my career as a banker doing an analysis of a large furniture and appliance vendor. And they promoted financing of purchases. And when I did an analysis of their financial statements, more than 90% of the profit of that institution came not from selling furniture and appliances, but came from the hire purchase financing. And those customers of those institutions that utilize those financing options deserve the same protection that we have put in here.
That's right. That's true.
Banks. Banks, even though perhaps the encouragement and the growth of this sector occurred because banks traditionally didn't offer much in the way of service to the micro, small, and medium-sized entrepreneur, the person who didn't have the formal collateral. But given the growth in recent years, and given not just the growth, but the greater transparency into the financial affairs, as some of these companies have listed on the stock exchange, the banks have realized that this is a profitable segment of the market that they've been ignoring. And banks are more and more going into the micro and small segments of the market. But those customers of the commercial banks will not enjoy these protections. Why? Will not enjoy these protections. And when we consider the balance sheet of the microlenders versus the commercial banks, we see that we're really dealing with a small fraction of the total. So we're offering protection, which is welcome, but we're offering that protection only to a small segment of those who need that protection. So the truth of the matter is, we shouldn't have Part 7 in this bill at all. Yeah. What we should have done is lift out Part 7 and create a truth in lending law that would apply across the board, whether the lender is a bank or, let me say, not just truth in lending, truth in the provision of credit, because some may not call it loans. It could be hire purchase, it could be taking goods on consignment, but which have a built-in financing charge in there. So really, we want a more omnibus bill that would protect all consumers subject to deceptive lending, deceptive credit practices, or predatory credit practices. The truth of the matter is, Mr. President, coming up in the banking sector, I well recall, and I'm not talking, you know, we talk about the bad eggs in the microcredit sector. I'm talking major commercial banks. In some cases, we had many international banks operating in Jamaica when I started in the industry. And those banks use something called an add-on rate. That was their method of calculation of interest rates. And depending, of course, on the term of the loan and the add-on rate, the effective rate was often or could be twice what the add-on rate was. But very few people, I see Senator Webby saying 3 times in some cases, but very few customers had the technical expertise to calculate what their effective annual rate was. So when I see the mode of calculating effective annual rate set out and the obligation to the lender to disclose that up front to the borrower, to disclose that in their advertising, I welcome it. But I say, why just the microlenders? Why not apply this to banks, hire purchase financiers, anybody who is extending consumer credit in whatever form deserve the same protection. Now I want to turn to the third leg, so to speak, of the Microcredit Act in terms of our institutional framework. And that is the appeals tribunal. Because I want us just to create a sort of architecture in our mind. So you have the microcredit institutions, you have the prudential type regulation offered by the BOJ, you have the consumer affairs type protection offered by the Consumer Affairs Commission. And then you have this appeals tribunal now, which really is, in a sense, some protection for the actual institutions, their employees, their directors, their shareholders. Because this appeals tribunal really has a very narrow mandate. Yes. It really is only where somebody has failed to be deemed fit and proper, that there is a review body. There is a body that they can appeal to and say, no man, I have tried to live, a good life, a life of integrity, and something may have happened that I feel I was unable to pay a loan 20 years ago because I lost my job. That doesn't mean I'm not a fit and proper person, and therefore they want to appeal against the initial judgment. That's a good thing. But why have this fit and proper tribunal, once again, constrained to such a narrow body of activities, a narrow body of institutions? Fit and proper is now something required for a wide range. First of all, any financial institution, virtually, any licensed institution that you want to be a manager, a director, or a substantial shareholder, typically you need to have pass a fit and proper test. So this is becoming increasingly common. If you want to apply for a firearm license, the FLA will have to deem you to be a fit and proper person in their context. Fit and proper is something that is increasingly required. In fact, fit and proper is not required for parliamentarians. Perhaps it should be. But I even recall some years ago, Mr. President, the then Contractor General was suggesting that contractors who bid for large government contracts should also pass a fit and proper test or meet the criteria, the fit and proper criteria. So fit and proper is something that is becoming more and more widespread. And again, rather than set up this appeals tribunal that's going to have such a very narrow mandate, should we look, does this really need to be part of this particular legislation, or do we need something that has a more general application where appeals against a negative fit and proper finding or an adverse trace, that is sometimes called, there is a body that can be appealed to for justice or mercy. So with these just sort of remarks on the overview of the bill, and what I think is unfortunate that we're trying to use this to address a number of areas that it would be better if we left them out of this bill. We narrowed the scope of this bill, and we allowed the Consumer Affairs Commission, or rather the consumer protection elements of the bill, to be applied much more generally for the protection of consumers. Now, if I just turn, Minister, and make a few comments on specific clauses of the bill. A number of technical points were made by the leader of the opposition during the debate in the lower house. And I didn't have enough time to watch on PBCJ the entire debate. So there may be points that were made that the minister responded to. And if so, I apologize for not being able to, in the rush circumstances, to be able to look at the whole thing. But let me start with section 6. In part 2, it deals with section 6 does not make provisions for information to be disclosed by a court order. And I'm sure this was addressed, but if the minister could help me with it. Similarly, section 6.1c allows for disclosure to be made for the purposes of investigation, but doesn't seem to provide for it to be made for the purpose of prosecution. And this is a technical point, but I would appreciate if the minister responded to it. I want to move then to section 9.1 was the amendment taken, and section 9.1 should also be subject to section 64. Section 9.3, this is a concern, particularly as this is new, it's going into transitional arrangements. Section 9.3 says a contract for the provision of a microcredit service shall be unenforceable if the contract is entered into by a person who is offering a microcredit service but has not obtained a license. And Minister, just similar to how you discovered or it was realized that, for example, a company, an employer offering employee loans, if we had not made that amendment, would have been captured as an entity offering a microcredit service. There may be other cases that we have not anticipated. And to make the penalty being the unenforceability of the contract, particularly if it was entered into out of ignorance. There was no... Yes, good faith. There was, if, for example, as I said, if we hadn't caught that amendment and an employer made a whole series of employee loans, they may all have been nullified and caused the employer great loss, even though...
There's a union man. I too would be.
So, I again wonder if the effect of this has to be, particularly as we're in a transitional period, or we're going to be going into a transitional period, people will be adjusting to the new legislation. People may not understand the implications if the only remedy is to deem the contract unenforceable. And if it was, it's microcredit, so if it was only one, but if it's a whole series, a whole class of contracts become unenforceable, it could be very serious. Section 26(1)(b). This, well, let me just, a small item, 25(1), supervisory measures, where the supervisor is of the opinion that the licensee has contravened or is contravening a provision of this act or any other enactment. And it goes on to say the supervisor may do one or more of the following. Again, the suggestion had been made that rather than just contravening a provision of this act, Minister, if we could have put in there, including contravening the conditions of a license or any other directive. I know it may be, sorry, the direction, rule, order requirement is mentioned later, but I'm not sure if a condition of a license is included there. Again, it's a technical point, but raise it. But more important is 26(1). 26(1) says the supervisor may suspend a license granted under this act if any one or more of the following circumstances applies. 26(1)(b) says a substantial shareholder or an officer has been charged, not convicted, has been charged with an offense involving fraud or dishonesty. Now, our Constitution has a presumption of innocence. So to give the supervisor the powers to suspend the license on the basis of someone just being charged seems unfair and unjust. We have seen many persons charged and end up, not being convicted. So just being charged, I don't think is sufficient.
You never put lawyer like Charlie.
And the fraud might even be against the company. So.
Yes, and no, but there, I want to go further. A substantial shareholder, let's say a substantial shareholder is charged. Now the definition of substantial shareholder is someone who holds 20% or more. Now, you imagine the licensee to be a company listed on the stock exchange. Shares are being bought and sold every day. It has a wide float on the public market, on the Jamaica Stock Exchange. Somebody acquires 20% without even the knowledge of the manager, the board, the controlling shareholders. They get charged, and the other 80% of the shareholders would be subject to the institution's license being suspended and the value of their property being seriously damaged. Because as you know, in the financial sector, reputation is a big part of the value of the brand. So I think there are two elements to this. One, I don't think it should be just on the basis of someone being charged. And secondly, it shouldn't apply to just a substantial shareholder. If it was a controlling shareholder, it would be different. But somebody who is a substantial shareholder, who may only have 20%, to then precipitate a suspension of the license, that would cause the value of the investment of the other 80% shareholders to fall precipitously, I think this is not good legislation. Mr. President, let me just quickly. Similarly, in Part 4, under governance of licensees, Clause 31, every licensee shall ensure that each substantial shareholder and officer remains a fit and proper person. How is that possible? How can I, as an employer, ensure that everybody who is employed to me, who may have been, or every officer rather, who is employed to the company, who may have passed the fit and proper test upon the commencement of their employment, something happens that causes them to no longer qualify as a fit and proper, how would the company have a responsibility to ensure that each officer and each substantial shareholder, once again, who may not even be known to them, because the 20% shareholder may be a company, and the ultimate beneficial shareholders may not be obvious, and especially during the transitional period, it may be difficult to ascertain who those are. So again, Minister, I think this is putting a burden of responsibility on the board and the licensee that I don't know how, as a practical matter, they could ensure. I think it might be better to say, if the person is no longer fit and proper, if that is brought to the attention of the board of directors or the licensee, they have some relatively short period of time to a duty to act on that. But to oblige them to ensure that the person remains a fit and proper person, I think we're, I just don't see how that can be guaranteed. I spoke in the introduction, Minister, about the narrow scope of the appeal tribunal. And it really says in section 41(1)(3), a person aggrieved by a decision of the supervisor in relation to matters specified in subsection 4 may appeal to the Microcredit Appeals Tribunal. And they may appeal the matters referred to in subsection 3 are A, any decision as to whether a person is a fit and proper person, and B, any objection as to whether an external auditor appointed under section 35 does not meet the criteria specified in subsection 1 or 2, in subsection 1 or 2 of that section, or any decision for the removal of such an auditor. Auditors have a professional body that certifies them. So it's hardly likely that it will be 4B will be what will be taken to the appeals tribunal. So essentially the only thing left is 4A, which is to determine a fit and proper person. And as I said earlier, I think if we had appeals tribunal for fit and proper that applied broadly across the financial sector rather than being limited, the financial sector, even outside of the financial sector.
Speaker's time has expired.
Mr. President, might the Speaker's time having expired, might he be permitted to complete his presentation, which I understand will be another 15 minutes?
President, is that the Speaker's time be extended for him to complete his presentation? The ayes have it. Senator Bunting.
Thank you, Mr. President. So we move to Part 7, which, as the Minister pointed out, is a key section of the legislation. But as I said in my introduction, I think the protection of consumers from predatory lending, predatory extensions of credit, deceptive practices in terms of the interest rates, etc. I think that protection should be afforded to all consumers, not just the customers of micro credit institutions. But looking at some of the specific elements of Part 7 and 43, Clause 43.1 in particular, it says where a licensee grants a loan to a consumer, the licensee shall provide the consumer with a loan agreement, and the loan agreement between the parties shall be disclosed to the borrower prior to its signing and shall contain contain the particulars relating to, and A2 says the date on which the loan is made and disbursed. Now, as a former practitioner in the lending business, I can tell you when you do a loan agreement, it is typically conditional on a number of events which trigger the disbursement. So it's going to be impractical at the time of doing the loan agreement that you can already detail the date on which the loan is disbursed. Usually it is anticipated that in some relatively short time from the signing of the loan agreement, once the conditions precedent are met, then the loan is disbursed. So I would just point out as a practical matter, it will be difficult. Sorry? This is 43 1A2. Again, this is a technical point, but I think from my experience in credit initiation and disbursing loans, it's not really practical. No, but a lot of microcredit loans still have some form of security. Yeah. Okay. And that security often has to be perfected before it can be disbursed.
Salary deduction.
So if it could even be a letter from an employer confirming a deduction. So all I'm saying is, and it is not a point of principle, you know. I'm just saying as a practical matter, I don't see how this will be achieved. I come to clause, where am I now? 43 D2. 43 D2 says where pursuant to subsection 1A4, property in the form of money is given as security for the performance by a borrower of his obligation, the money shall remain the property of the borrower and shall be held in escrow by a deposit-taking institution. Now, remember, by definition, microcredit institutions are not deposit-taking. So therefore, they would have to have an arrangement with a bank to set up an escrow system, which is going to be costly and impractical for microlenders, given the size of the loans, etc. So I think a better formulation of this section would be the money shall remain the property of the borrower, subject to the security interest of the lender or the microcredit institution, and take out the held in escrow by a deposit-taking institution, because that is not going to be practical, and you're going to have to rely on your competitor to hold your collateral at a cost, and you know, significant documentation as well. So I would ask you, and it's simple to amend this since we're doing a set of amendments here. Clause 45, which speaks to the obligation of borrowers. A person who applies for a loan shall provide evidence of that person's ability to repay the loan. This clause creates an obligation with no consequences for any breaches, I really don't think this belongs in legislation. This is for the lending institution to convince itself that the borrower can repay the loan. So I think we could really delete 45 entirely. It adds nothing to the bill. And then the important clause 46, which speaks to the interest rates on the loans and how they are calculated. And then it it has that important clause 46.3, which says, notwithstanding the method used to calculate the rate of interest on a loan, the rate of interest shall also be reflected as an effective annual interest rate. And where interest rates are being advertised, the effective annual interest rate shall be the most prominent interest rate advertised. Important clause. And again, I'm pointing out, this is where we're creating an asymmetry between the obligation we're imposing on microcredit institutions while allowing the banks free rein to continue their practices. I really tell you, Minister, the whole Section 7, and it's not that we're against it. We're for it, but we're saying it should be expanded to the entire spectrum of consumer credit. Let me now turn to the fourth schedule. This is, Section 48.4. For the purposes of investigating a complaint made under this part, the Commission may, A, in writing, advise the licensee concerned of the general nature of the complaint. So this is the Consumer Affairs Commission receives a complaint from a customer of a microlending institution. They then go to investigate the complaint. But imagine a situation where you could be managing an institution, a team of investigators arrive, but they may or may not advise you of the general nature of the complaint. It would seem that natural justice requires that the investigators say when they come to do their investigation to the licensee, here is the general nature of the complaint that we have received. They don't necessarily have to identify the complainant, the specific complainant. But I think, it can't be just that they come and they're at large in the institution without even giving the management without even giving the management an idea of what complaint they're investigating. So that again, Minister, a simple, rather than may, we just could put shall, or at least for A, for 4A. In 49, which is referring to the Code of Conduct, and it's speaking of the formulation of the Code of Conduct, and it says that, the supervisor, or rather the Consumer Affairs Commission would consult with the supervisor, such other person as may from time to time be charged to carry out similar functions, and any other person who, in the opinion of the Commission, are relevant stakeholders. I don't think this is the best formulation. I think we should ensure that industry associations representing the industry be one of those stakeholders that are consulted by the Consumer Affairs Commission in coming up with the recommendation for the code of conduct. I'm not saying they would have any veto over it, but for good order and to perhaps avoid unanticipated consequences and context, I think it's important that we could, where we put in that section, and any other person, we could easily amend this to include industry association representatives or something, some wording to that effect. Again, Minister 54, I'm now in part 8, winding up of licensee. And 54.1 speaks to, subject to subsection 2, the winding up of a licensee shall be subject to the provisions of the Insolvency Act. And then subsection 2, which is the only part subsection 1 is subject to, speaks to where the licensees are part of a financial group under the Banking Services Act. The Insolvency Act shall not apply. But by the time we reach to 54.3, it says where a licensee passes a resolution for voluntary winding up, and then goes on to the issues. Now, 54.1 says the winding up of a licensee shall be subject to the provisions of the Insolvency Act. But if it's a voluntary winding up, why would it be subject to the provisions of the Insolvency Act? In fact, I think a voluntary winding up, I mean, one of the attorneys can correct me, but I think that is covered under the Companies Act rather than the Insolvency Act. So I don't think, 54.1 should be so all encompassing, where it says the winding up of a licensee, even a voluntary winding up, should be subject to the provisions of the Insolvency Act. That doesn't seem to make sense, but perhaps you can explain it to me, Minister, in your closing remarks. So there may be one or two other points, but in committee I think I will deal with those. But just in closing, Minister, I really think just from the sample of issues that are raised here, it would have been good to have a little more time, because I think I may have identified a few more myself if I had more time. And all the members who want to improve the bill, and we all want to improve the bill, would have perhaps some additional points. But in terms of one of the things that I have that as a point. So given the exigencies or the urgency of the passage of the bill, it provides for a review after 5 years. And perhaps, obviously it's up to 5 years, but in practice, when it's up to 5 years, it's usually at the outer limit these things take place. Perhaps we could amend that to make it after 3 years, which would give us sufficient time for the year transition and 2 years of operation, and seeing any weaknesses in the bill in operation. So that is another suggestion I would make that I think would help to mitigate any unintended consequence of having to push the bill through so quickly. But in recapping, Minister, I have no problem with the regulatory authority element, the BOJ providing the standard type of prudential type regulations, ensuring that these institutions are not used to facilitate money laundering, terrorism financing, or any other criminal enterprise. But that if not today, then soon we can look at lifting out the consumer protection element of this bill and creating a piece of legislation that affords these same protections to the entire universe of consumers who are using credit and would be subject to some kind of predatory lending or deceptive advertising or any other unfair business practice. The appeals tribunal these members will probably be like the lonely Maytag repairman, as an ad used to say for a reliable dishwashing, washing machine, reliable washing machine company. Because usually once persons pass a fit and proper initially, it's not often that you'll have people dropping out after that, particularly as they're officers or directors of a licensed institution. So one of these tribunals should be able to serve the whole sector or even beyond the sector, and it would make for a more efficient governance structure, particularly in these times of financial restraint. So, Minister, thank you for paying close attention to my presentation, and I hope we can accept some of these suggestions for amendment. Thank you. Thank you, Mr. President.
Thank you very much, Senator Bunting. Senator Webby.
Thank you very much. Thank you very much, Mr. President. Sorry. Thank you very much, Mr. President. Let me start off my presentation, Mr. President, by recognizing the contribution of the leader of government business. I thought it was an excellent presentation that took us through all the stages with a lot of clarity, certainly for me. I also want to recognize, and this is his first presentation where I am here, Senator Bunting. I thought that was a really good presentation, Senator Bunting, and you raised some very important points. Having said that, Mr. President, I rise in support of the Microcredit Bill 2021. The truth is, colleagues, that this bill has been in the making for several years. And in fact, based on my research, Mr. President, it goes as far back as 2013, going through different administrations. And in 2015, under the external facility funding from the IMF, that was actually a part of the requirement to pass the Microcredit Act as one of the measures to improve access to capital for MSMEs. So it has been long in the making and well overdue, Mr. President and colleagues. So I'm really pleased that it is now in the final stages for completion. What I was heartened to hear and what I've read, the Minister of Finance, Honourable Nigel Clark, he has actually had several rounds of consultations with the various stakeholders, which I think is very important. The Jamaica Microfinancing Association Limited and the Jamaica Association of Microfinancing. So I really want to congratulate Minister Clark for having discussions with a number of stakeholders. I also want to use this opportunity, Mr. President, to thank our technocrats from the various ministries who have worked tirelessly on a tight timeline to get this done. So I salute you, my colleagues over there. As I said earlier, and I know my colleague Senator Lambert Brown always is in agreement, that consultation, Senator Brown, forms an important part of our legislative process. And the truth is that sometimes, Senator Crawford, stakeholders don't agree eye to eye, and that's part of life. But I believe that there is general agreement that this is in the best interest of the consumers, the microcredit institutions, and Jamaica that the industry is regulated. And I made a special note, Senator Bunting, about your interest in ensuring that the consumers are protected, not only by this bill, but the wider consumer protection, and I have noted that very carefully. I think there is some difference of opinion as to what is the right balance, because there's always a balance in terms of the consumer, the regulator, the microfinanciers. But having gone through the bill in a fair amount of detail, I think at this time we have come up with what I described, Senator Williams, as a right balance in terms of the consultation and where we are going. I don't think the leader of business and government said it, and Senator Bunting alluded to it, but I don't think we can understate in any way that this bill forms a key legislative reform that must be passed if Jamaica is to remain compliant with the Financial Action Task Force and the Caribbean Financial Action Task Force. And I can tell you, as someone that is involved in business and the private sector, if we are not compliant, it's going to be devastation in terms of the general economic activity in Jamaica. And that's the real issue here, that we have to ensure that we are compliant. And this obviously will improve the country's anti-money laundering and combating the financing of terrorism framework. If not, it's going to have serious implications. Mr. President, one of the comments that I often hear is that the microfinanciers, they lack transparency in terms of how they are funding. We know that a bank, Senator Allen, you get your deposit, that's how you are funded, and you unlend it. The question is, how does these microlenders fund their business that they can unlend? And there are a lot of speculations. I have no proof of how they raise their funds, but with this legislation, it's going to ensure that there is transparency in terms of how the funds are raised. And the anti-money laundering concern, Senator Hill, will be right out there in terms of transparency in terms of how they are funded. I want to say that I have done quite a bit of research on microlending from my days in college. It has been an interest for me. And I've looked at the Bangladesh model, which was actually established in 1976. And when you look at some of the case studies, Senator Morris, it is clear that the structure that they have in Bangladesh is actually alleviating poverty. And the Grameen Bank is often used as an example of how a proper microfinancing bank operates. So I believe that this sector is extremely, extremely important to Jamaica and most developing countries. So I want to make that clear before I continue my presentation. In fact, in a BBC report, it was stated that about 10 million, Senator Gale, came out of poverty between 1990 and 2008 because of the structure of their microlending facility in Bangladesh. And I think that's a model that we can study going forward. Obviously, there are pros and cons, but when you look at it as a whole, the Bangladesh model is actually quite good. Although, for those of us who are cricket fans, I'm sorry, Floyd Morris not here, they beat us twice now. I never thought I'd stand up in this parliament to say that Bangladesh beat the West Indies twice. Yes, sir. Mr. President, I also believe that I also believe that if we get this right, as we use the Bangladesh as an example, it is surely going to boost economic growth and job creation in our country. I have no doubt about that. You know, when the Minister of Finance stood up, and I've read it subsequently, that there are over 200 microcredit institutions operating in Jamaica, I was basically shocked. I really did not know that there were so many. In fact, in my mind, Senator Scott Motley had 20 in my mind. So when I heard 200, I was really shocked. But what this is saying, colleagues, is that with a large number of players in the market, they're actually filling a demand that is out there in terms of lending. That's what this is saying. And in fact, if you look at the numbers from the Development Bank of Jamaica leader, they have actually disbursed 10.8 billion to more than over 100,000 entrepreneurs over the last 10 years. So there's obviously a huge demand for microlending in Jamaica. And again, I refer to the Bangladesh example. So if you want to look at the profile, which I think is important as we debate this bill, of a typical customer of a microlending, is basically, I think Senator Bunting mentioned, it's basically an individual or individuals that I refer to them as unbanked. They can't go to a traditional bank and get a loan because they really don't meet the traditional collateral requirements. And if you look closely at what they are borrowing for, is to finance their own livelihoods. They're borrowing for health care. Grandma gets sick and have to borrow some money quickly to pay the hospital bill. Small business creation. A man want to do a little hustling, him go to a microlender and borrow. Housing improvement and other needs. I've actually heard some very encouraging stories, though, that some of these micro borrowers, or the borrower from the microlending institutions, some of the more reputable institutions, actually graduate. They have done so well in terms of managing their affairs that they graduate to the traditional banks because their business can now have the right cash flow to graduate. And I call those, in my mind, success stories. So we have examples of that. The other comment that I hear quite often is that the feeling that they regulate in the industry, and sometimes Senator Bunting will understand it, sometimes we tend to overregulate, and that it will dampen the entrepreneurial spirit of some of these institutions. But while I hear that argument, I believe that it is extremely, extremely important that we protect the consumers. When you look at the profile that I have just mentioned of who is borrowing, we need to protect the consumers, and that's what this bill is about. It may come across, Mr. President and colleagues, that there's a lot of negative about the microlenders. But I can tell you, I have interacted with a few, and I say this without apology, that they are very good and professional microlending institutions in Jamaica. Not everybody is this bad microlender. You have some that are very good and very professional. And the truth is, Senator Allen, the transition for those more professional ones will be that much easier as they become regulated under the BOJ. The other concern that you often hear, and we did mention it in the presentations, and I'm really happy that our Minister of Finance is actually doing a fantastic job in my mind. Where in the initial bill, Senator, it was being tied to the Treasury bill, and there was a cap there. And the minister actually met with them, and they came to an agreement of how it's going to be handled which you quite nicely went through with us. And that's the importance, again, as I said earlier, of consultation and a government that is listening. I had, all of us in this Senate here, you have somebody that you help out from time to time. And one of my colleagues who I help out from time to time to do his little business came to me with all smiles and pride and bouncing. And he said, "Bossy, I just got some money from a microlender." I said, "Oh?" I said, "What are you going to do with it?" "I'm going to do a little buying and selling. Buy a little cigarette and buy a little bag juice and sell." So I said to him, "Senator Crawford, so what is the interest rate?" He look at me blank. He said, "Boy, I don't know what the interest rate is. I know that he borrow $5,000, $20,000, and I know that I'm going to pay back $2,000 for the next 4 weeks." And I just call the numbers. When I go like this and put it in my calculator, to what we call the effective rate, colleagues, it's over 100%. He didn't even realize that the cash flow is going to time up. So when you have a flowing cash flow and you're not making no profits, what is going to happen is going to reach a stage where the cash flow dry up because you're not making any profits. And then when that happens now, you're going to get on what you call the debt cycle. Now, these are the consumers, these are the Jamaicans, Mr. President, that we need to protect. He don't know, all him know that he have to pay back $2,000 out of the $20,000 whatever and buy and sell cigarette. And it is a shame. It is a shame that they're taking advantage of some of these people.
Mr. President, at 1:20, might we be permitted to sit beyond 1:20?
Let me assure you it's 1:20 somewhere.
Might I ask, though, that the Senate be permitted to sit beyond 1:30 to complete the business of the day?
Members would have heard the question. Those in favor? Against? Continue, Senator. I interrupted you because I thought you were at a spot where I could have interrupted you.
I'm not going to comment, Mr. President. We can have lunch over that. Well, I did finish my story of a gentleman who is doing his little buying and selling, being taken advantage of. So I want to make a suggestion, colleagues, that the Consumer Affairs Committee, when we talk about market rate, what is dependent in terms of having a true market force is that you have information. There have to be information out there in terms of the various interest rates. And I want to recommend that the Consumer Affairs Commission publish in both newspapers interest rates that is being charged, but effective interest rates that is being charged by these institutions. They do it with the supermarkets, Senator Golding. I don't see why they can't do it with the interest rates, because the person that is borrowing is not going to pick up the phone and call 5, 10 lenders. They need to have the information at hand. And I believe it should be mandated that the Consumer Affairs Commission publish on a monthly basis the effective interest rates that is being charged. So somebody that is borrowing from a microlender can look on the newspaper and the red will show up in terms of, oh, this man charging the highest rates. I want to make that recommendation. Mr. President, I'd like to highlight a few other provisions in the bill that address some of the issues related to the industry. There have been cases where vulnerable consumers are exploited, and I did give an example, and strong-arm tactics are used, which is never justifiable under any circumstance. In order to discourage that practice, Section 53, it is an offense to use violence and threats against borrowers. I've heard Senator Bunting Senator Bunting, I've heard, I haven't seen any proof of it, but I've heard, and you will appreciate this, that the delinquency ratio on loans for micro lenders is lower than the traditional banking system. And I think that is something that certainly we can do some research on. I'm not 100% sure it's because of the strong arm tactics, because knowing my Jamaican people, right, we are proud Jamaicans, and sometimes it's a small man that will pay back the loan before the big man, right? So I'm not sure if it's a strong arm tactic, but I raise that point because it's an important point in terms of profitability of these micro lenders, that their delinquency ratio is actually lower than the traditional banks, and I think that's an important point to make. I also want to make another recommendation, Mr. President and Madam Leader. It is about financial literacy. I believe as a country, and this can be led, I would think, through the Jamaica Business Development Corporation, for these small business people, that we need to have a comprehensive training program for these people that are borrowing from the micro lenders. I believe that is extremely, extremely important. They need to understand, as my friend did not, the basic creating a cash flow and what is the difference between cash and profit. So while we make this legislation and this bill is being passed, there's a lot of other work to be done to ensure that we achieve the ultimate objective of ensuring that this legislation would be a catalyst for economic growth and job creation. There's a lot of work to do, and I believe that we need to ensure that we have a program of training for financial literacy. The other point before I wind down my presentation is that as someone that is involved in the financial services industry, reporting to the central bank, Senator Sinclair, can be quite intimidating, especially the reporting requirements for these small business people. And that's the reality of it, right? I want to make 2 points. The first thing is that we need to ensure with 200 or so new clients of the BOJ, Senator Allen, we need to ensure that they are properly trained. And they are actually properly trained to deal with microlenders. Because to deal with a proven from Senator Bunting and a Mark Golan from proven is different from the other microlenders. So we need to ensure, or Don Webber from First Global. We need to ensure that the BOJ is properly resourced to deal with this new legislation. And the BOJ actually to be properly trained to deal with the microlenders, because they have no experience in dealing with microlenders. And that should also be put in place. As I mentioned earlier, reporting to a regulator can be quite intimidating. And we need to set up a system of what I describe as hand-holding. In other words, our microlenders are going to face a thing where they have to now do these reports. I'm not sure how complex it is, but I know for banks it's quite complex. But nevertheless, they need the training of how to meet these requirements. And they're going to need hand-holding, or else they're going to get frustrated, and it's going to defeat the purpose of what we're all trying to achieve. I would also like to say to the microlenders, and there are some excellent microlenders, I can tell you, that now is the time when you have change, and sometimes change can be intimidating. There's a lot of uncertainty, but change can also be very good. Because with this regulation and this bill, it is going to create a certain level of discipline in your respective business. It's going to create a certain level of discipline. And in the long run, your business is going to be better off in terms of sustainable growth because of this discipline and this governance structure. So I'm saying to the microlenders that this can be a big, big positive for your business. Big, big positive. When you have that discipline and that governance structure around you, is going to ensure that you have that you're going to have growth. I also want to encourage the microlenders that in terms of the reporting and the new regulations and so, you need to embrace technology. You need to embrace technology. And research is out there, Senator Scott Motley, that they're relatively inexpensive software. So these microlenders can acquire the software to ensure that their business run a lot more efficient and meet all of these requirements. So, Mr. President, in closing, I would say that this bill has been long in coming, and I support it. I believe with the right implementation, and I've made some suggestions, if these are adopted, it can really meet our objectives of creating growth through these microlenders and creating jobs through these microlenders. And especially, Mr. President, in what we're facing now with COVID-19, we're going to need all hands on deck to ensure that we have the resources, financial resources, and access to capital so we can grow our economy. And with that said, Mr. Chairman, I thank you. I think this is important that we pass this as quickly as possible. Yeah.
Lend my chicken.
Thank you, Senator Webby. Senator Crawford.
Thank you, Mr. President. Mr. President, I too share the concerns raised by other members of this side about the short period of time that we had to review the bill. This is not the first time that this will happen, and this will not be the last, but the size of the bill also calls for it to be even more unreasonable. 88 pages to review. And in reviewing, led you to other aspects of law to also review, like the Lending Act and other things. Lending Services Act and other things like that. Well, Mr. President, what we're here to discuss as it relates to microcredit entities is what I like to term the lender of last resort. It is mainly the people who have no other option that have gone to these entities. One of the reasons that they are the lenders of last resort is the cost compared to other entities. So if you can get a loan from another entity for 20%, you might get it from this lender of last resort for 40%. And so any reasonable person would have chosen, if he had a choice, to use the other entities. So therefore, because of the number of unbanked individuals in Jamaica, because of the number of persons operating in the informal economy, because of the number of people who are living day to day in our society, there has been proven to be a great space for persons willing to take on the risk of lending these persons some funds. As you said, Senator Webby, microlenders are often frowned upon when we hear the rates, the this, the that. However, if we acknowledge those they are likely to lend, they're also taking on higher risk. And the natural economics and accounting principle is that higher risk demands higher returns. So one of my colleagues said to me, if you should look at a credit card interest rate, it's not very far from many micro-lending rates. The credit card is telling you 40% per annum. So if you check it out and I go to a micro-lender who's bearing almost the same risk as if I use a credit card and don't pay, because they have very little to hold, then, exactly, then the rates are not as exorbitant as it sounded to me initially when I heard. So we have these people who, many of them actually are borrowing only on their name, their good name. Even sometimes when you hold a mattress or you hold a, you hold a settee or you hold a dresser, it is only for the purpose of shame. It is to come for the dresser and besmirch your good name. And maybe that's one of the reasons, because some of us can hide behind company name and things like that. But these borrowers, them come at Damien yard for his bed. And so, in protection of the only thing him have his name, he makes sure him pay. You have to look into these things. And so, what we have recognized is that there's a set of persons perceived to be incapable to pay that has proven over time that they are indeed able to pay. You see, unwilling to pay. You see, Senator Mayor. Senator Mayor. It's a new thing happening. Soon say Minister, Senator Mayor. One of the things why this side proposed the rent to buy as an option for ownership was that in renting over time, you prove the ability to pay. Sometimes up front, when you go with your pay slip and your thing, there's no evidence that you're getting money from your auntie, you're getting money from your cousin, you do little cheese chicks and bag juice on the side, and so therefore man don't think you can pay. And what the banks and some of the more formal entities are realizing, Senator Lambert, is that they are able to pay, and so they're going in the space. Yes. And so the microcreditors who were lenders of last resort now competing with instruments of last resort from some of those who were lenders of first resort. Meaning some of the banks now are in that space with specific instruments competing with the entities who were of, and I understand some are now buying some of these entities and they're coming out. And so I want us to analyze who these people serve, as you said, Senator. They serve in the main the industries for the poor, the low barrier industries. They serve taxi industry. They serve vending. You would know that from downtown. They serve entertainment. Keep a local party and go down there for a 40 grand or 50 grand. And because we have a habit of using ourselves, in marketing we call it projection, projecting ourselves onto other people, I say, I cannot understand how a man borrow for 40% to run a business. But him not borrow for 10 years like me, borrowing for 5 days. And him don't have expenses like rent. Him keep it in the road. The parties in the road. And him possibly don't give the mayor any of it for getting a permit. And the light might be a choke. And when you check a stock, him possibly make 200% profit. And so he says, this is a good decision for me, who can make 200% profit for pay, basically 5% in the period of 3 days. And so this is one of the realities that we are facing and going to increasingly face, that there will be a need for facilitation of more persons participating in industries for the poor, profit seekers who don't have high assets to invest. Because, you see, wages are now less and less likely. So you have to now seek profit. There's only two ways you can earn a living. You can only learn a living from either wages or profit. I don't know of any other way. Illicit. Yes. And some say that it's still profit. It's just an illicit business. Yeah, it's an illegal business, but he still make a profit. But there were a set of people, Senator Longmore, who used to work at a factory before automation and mechanization took away those jobs. And now they get laid off. Remember when the first wave of laying off happened, no taxi emerged? Every man buy a taxi and then start make a profit from offering the service of a taxi. You would know, as a representative of workers, as soon as him get laid, I'm going to buy something and sell it back. He become a vendor. He select some clothes from foreign, many of whom now own houses in Portmore and things were higglers. Huh? Well, you would understand. And Honda Civic, that's like nothing. But they go. Many also say, may I go keep something. May I have a we call it again, round robin. That's now a big thing in the inner city. When him now have no work, him say, may I have a round robin. And it depends on his personality, on the number of friends that him have and thing, and him keep something. And so all of these people are now moving from wages to profit. And as COVID now redefine our society and redefine our economy, even within the medium term, there will be many more who were once wage earners who are going to be seeking profits. Senator from St. James, you're seeing it now with those who used to work in the hotels. And I'm a part of that industry. I'm a supplier to hotels. And every time we think that this thing is turning the corner, it turned back. Every time. Hey, listen. I remember some hotels called to say, prepare yourself. I sell eggs to hotels. And egg is a staple for breakfast for an American. An American want him omelette, he want him scrambled eggs. It's a staple. The hotels call us as egg people and say, be ready for December. But yes, that chicken take 21 weeks to start lay. So they say, be ready, because they don't want when the people come. Yeah. December, nothing. You start heat layers. You start cook layer food. And then all of a sudden you hear, Canada, oh, you have to now have a PCR before you return. England, oh, you have to have a PCR. And then 67% of our market, United States, oh, you have to have a PCR before you return. That is now going backwards. Then the visitor starts to say to himself, why would I take that risk of going? Because not only may I have to have a PCR, what if I am positive? Where am I staying now? It's not just a question that, oh, you have to have a PCR. It sounds like you're saying, once you do the PCR, positive or negative, you come back. It's not like that. You must be proven negative before you come back. So if you're positive, you better find somewhere to stay for 14 days. It's now become a barrier risk to travel. And so now some of the properties that were open said them are going to lock back. I'm explaining this because there's a wholly thousands of workers who now are going to start to seek micro loans to survive day to day, but also to try a little thing, to turn a little life. And to that extent, Senator Bunting, we have to be very careful because we may be impacting the last resort for the people who are in need of these things. It's not the last resort for me. I might use it, but it's not, it's become a choose to. Because, Senator Webby, sometimes we say, oh, it's only these people. There are some people, like myself, that want the speed of the microlender that the bank don't offer. I saw a fellow who he said, if I don't know anybody, because he advertised at Airbnb before it was furnished. He was testing the market. Then he got a booking. The furniture sent me 300,000 quickly tomorrow. He was testing the market to see how it goes. You need 300,000 immediately. The bank might not be able to do that. You'll know of some people with a container to clear. Soup is a big thing now. Ramen soup is one of the staples of our inner city communities. A man says, I have a container ramen, $1 million. And by Wednesday, I give you 250,000 on it. Send him to Sophia, as you know, she has many millions to do. And so to that extent, we have to be cautious because the bill is going to impact the final area of survivability. And to that extent, therefore, we have to consider what is the true risk. I see 88 pages, but the risk in this business is really to the man who chooses to lend, is not to a saver as a bank. There's no risk to the person getting investment advice, so you have to protect him getting investment advice. This is really a person with some money choosing to take the risk and offer a service of lending another person willing to borrow. It don't need equal intervention and government protection as a man making decisions with my money who don't participate in the decision. Exactly. So a bank takes my money and then makes decisions with my money. Therefore, government have a duty to protect me as a person who has saved. But if Senator Bunting decides that he wants to lend some money, he doesn't have my money. He's not taking decisions with my funds. He's taking his own risk. So when we analyze who is at risk, we have to now understand what is the level of intervention and regulation that is necessary. Indeed, I hear the leader of government business say that that side is the proponents of free market. Limited government intervention is one of the #1 requirements of free market. So you can't be saying further government intervention and then say, oh, we're all mixed. Some of us kind of more left, some of us more right, but none of us here are total free. And so therefore, we have to be very careful. So the role of government, therefore, is not to the depositor, is not to an investor. The role of government really here is to ensure that there is not the consumer is not unfairly dealt with, disadvantaged. And that is a necessary role to play because we have acknowledged the average type of borrower within this microcredit, the average circumstance of the borrower. And I'm making that clear because sometimes your knowledge don't kick in because of your circumstance. You need this money right now, so you're over the barrel. And even though everything tells us that this is not a reasonable thing, it's the only thing available to me. So therefore, I understand the need for protection, but I ask what further protection this bill gives that the Lending Services Act did not give. If the intent is to protect, because before this bill, the Lending Services Act would have covered lending by these institutions. I beg your indulgence, Mr. President, but let me read how one of the things from the Lending Services Act here. It says, where proceedings are taken to court by any person for recovery of any money lent, either before or after commencement of this act, there is evidence which satisfies the courts that interest charged in respect of the sum actually lent is excessive, or that the amount charged for expenses, enquiries, fines, bonuses, premiums, renewals, or any other charges are excessive, or that in any case the transaction is harsh or unconscionable, the court may reopen the transaction and take an account between the parties, and shall, notwithstanding any statement or settlement of the account, or any note, security, or agreement purporting to close previous dealings, create a new obligation, reopen any account already taken between them, and relieve the person sued from payment of any sum in excess of the sum adjudged. That sounds like strong protection, even stronger than some of what I'm hearing now. It goes further to say that in any proceeding in respect of any money lent after commencement of this act, that it is found that the interest charge exceeds the prescribed rate per annum, the court shall, unless the contrary is proven, presume for purpose of Section 2 that the interest charge is excessive. Whosoever shall, by any false, misleading, or deceptive statement, representation, or promise, or by any dishonest concealment of material facts, fraudulently induce or attempt to induce any person to borrow money, or to agree to terms on which money is or is to be borrowed commits an offense and shall be liable to summary convictions before the resident court. That sounds like reasonable protection. So therefore, I fear that if this new bill replaces for the purpose of the commercial lender, based on what the leader of opposition business said, that this will now, the leader of government business, you did not say the leader of government business said that the Money Lending Act will now go for non-commercial, friend-to-friend lending. But this one seemed to have provided even more protection than the current bill. Now, it may be argued that having to go to court was a onerous and barrier. And so therefore, these should be transitioned now in the same strength to the consumer affairs entities that is now being proposed. Because the type of borrower might equally not be a court, what do you call that type of person who loves to go to court? A litigious individual. And so to that extent, we have to be careful. Now, as was said by the leader of opposition business this time, the industry said that these regulations weren't encouraging the industry, which is contrary to what is being proposed, that they are encouraging the industry. The industry said it is not. One of the worries I have, as Senator Webby said, we hear that 200 of them exist. We only knew of 20, maybe 30. Some of us 5. It suggests that there's a multiplicity of micro, not big enough to be above the radar. In a year, we'd buy $2 million to lend. Can you recognize how that is deleterious to the micro? Wait, the cost, the risk, all of this serve as a deterrent. So when we say that 200 exists, and we only know, it's like you're saying how much farms exist. Of course we know about Jamaica producers because he's a big player. But we don't know about little farm around the road because he's not. There's a reason why we don't know of the 170. They don't advertise on TV. There's a reason we don't know of the 170. They're not listed on the stock exchange, neither junior or otherwise. And therefore, these obligations can kill. Will kill. And then become, unfortunately, like the cannabis licensing authority that basically disqualify anybody who are coming in without a big investment. Because I'm not only speaking to killing the current, it will hinder the future small man from coming in, working counter to the market forces that we estimate to protect the people, because we have removed a cap and now move to market forces which not only need information, as Senator Weber rightly said, but it need multiple players, it need a competitive space. Oh, Mr. Owen, Senator. There's a paper I want you to read called The 5 Forces, Porter 5 Forces. And it says one of the things that make an industry attractive to the investor is when there's no ease of entry. Ease of entry creates risk to the investor. So the current players are faced with high levels of competition because 21 senators can put $1 million each and go in and say, we're micro-lenders. Are you understanding what I'm saying? But a good idea, a good idea. Yes, I see Senator Longmore writing down our check for $1 million. But what happened now? We'd have to go through a year of activities to make sure that none of us don't, all of us fit and proper. A couple of us fail the first 2-3 months. Then we go through another thing. Then I might not want to absorb that risk, so it leave us with 20. All of these now create barriers to entry, which reduce competition, which then what? Drive up interest rate? Because we have now left it to the market. Are you understanding what I'm saying? I find that to be of great risk, and we need to be very careful. The other thing is that and I understand what the government is facing, Senator Brown. The government is facing requirements that they have to meet if we are to operate in the global space. That is indeed the key motive. That is the reason for the haste, and that's the key motive for the bill. The key motive is not to protect the customer, because as it can, but it's not the key motive. Maybe a motive, but not the key motive. As Senator Bunting said, some of these protections are not microcredit specific. Higher purchase. You spoke to that. Big problem, right? So therefore, they're not microcredit specific. The access to illicit money is not microcredit specific. We have to have a holistic thing, because supermarket can get access to. It's quite cash rich. Construction, wholesale, hardware, gas station. So these are not microcredit specific. In fact, to put it under microcredit alone almost besmirch. This is a new word. A word for January. the industry though. Because we feel that microlenders are almost automatically loan sharks, which as Senator Webby has said, is not true. They are very credible, upstanding persons in the industry. Farming, because you cannot tell a man how much him tree bear. You can imagine a man saying start a mango farm and say he has sold 20 million mangoes from 1 year because of the fertilizer he uses. Highly productive. So therefore, some of these areas are not microcredit specific. But the requirements of homogeneous laws must be taken with a grain of salt when we have heterogeneous circumstances. It must be taken with a grain of salt. The requirement for shared rules when we don't have shared realities. When I read about microcredit, it is mainly in poor countries. And as Senator Webby said, when you look at the Grameen Bank, India, Honduras, they have been known for it, Bangladesh. The difference, however, is that they started as non-profit. In the main, ours start as for-profit. And so that's one of the reasons why government have to make sure that the persons who are in need are not being taken advantage of. Because for-profit means profit maximization. That is the essence of for-profit businesses. But what I want to ensure is that we are not in a situation where to fit into these rules, international rules, we don't make sufficient lobby for our local reality. What's one of our local reality? Is it SIPP? Yeah, the securities in personal property. We decided, we started it when we were over that side. Which bank is taking 2 cow? And definitely 10 goat. Now take 10 goat. But I might be in a situation where I go to a man with my 10 goat, and I said to him that if you lend me 3 million, I can buy a tractor. But the bank's not taking that. Are you understanding what I'm saying? So when I see Section 46, Senator Webby, I'm concerned because what is proof that I can pay? It have not specifics in it. Section 46, Mr. President, it says that simply, sorry, I was incorrect, Section 45. A person who applies for a loan shall provide evidence that that person's ability to repay the loan. Full stop. What is that evidence? An income statement? What's that evidence? Salary deduction? That is what I'm saying. Because the microman basically operate where there is no evidence. Him operate. When a man come and say, me a keep a dance, but he doesn't have $1 to show.
Or a permit.
Not a permit to show. You see, when we say, well, you see, I'm saying, what is evidence that he can pay? The goat is not sufficient evidence and can dead tomorrow. Or them thief them. My party is not sufficient evidence, it can rain out. My sale is not sufficient evidence, I might not sell nothing. What is sufficient? I understand the desire now. But I'm saying that you're taking away the entire thing, what them operate on. It is on trust and flexibility. You're killing the exact thing that you are promoting. When they say know your customer, what is it? Proof of address? They're not paying a light bill. So don't frown on the bank, you know. Because the bank sometimes cannot lend them based on the rules the bank face. And so therefore, this little group of people who don't face the same rules emerged. And now we put in some of those same rules now to kill them. I don't think 46 should remain. 45. Instead, Senator Webby. That is why I made it. That is what I'm afraid of. But what I'm saying, I think that there should be a duty for counseling. When a man borrow a loan. I don't know how much it takes, I don't know what the cost is, but the person who's borrowing, he should be made aware, the person lending should have a duty of counseling. But I can't see us maintaining 45 to say prove that he can pay, because if he had proof that he could pay, he wouldn't get it at 40%, he would have gone for 8, he'd have gone for 10. I'll soon finish that.
Mr. President, the Speaker's time having expired, may I ask that his time for conclusion be extended?
Thank you very much. You have heard the question. In favor? Thank you, Senator Crawford. Continue.
Thank you. Thank you, colleagues. Thank you. The other thing, sir, is that I lost my train of thought here. I should 46 should be taken out. That was 45. Yes. In the same way that they did in the other place. But also, sir, is that I want, I said the counseling, correct, that's where I was. I was saying that there should be a duty for counseling. But I want to also add my support for the similarity of rules. If it is that I am comparing 40% as versus 60% disguised as 20%, then the customer is not sufficiently protected. If the other institutions can list as they see fit 17%, and when you really go, it is 52 on the basis of calculation, I think that there should be immediately, whether in this bill or some other space, for reasonable comparison. So when Senator Webber says that the Consumer Affairs should be able to list or should be designated to list, I welcome that proposal, because they would then be designated to list in a similar way. All rates must be listed in a similar way. But another individual should not be able to promote misleading rates and compete with the micro lending sector. It is an unfortunate and unreasonable method for us to do. I concur with the proposal that the entity should be a representative, should have a position, even on the panel, so that their reality and their context can be considered. Even if they have a non-voting position, he should have a position. The entity should make those recommendations. I also feel that in making the rules, they should be a part of that consultation as well when the rules are being made. And I think that how to lend should be left to the lender. You remove a competitive advantage if you decide by legislation how to lend. So if I want to lend without collateral, that's my business, because I'm not having investors. I don't have savers' money. It's my money. So if I put my money and lose my money, the risk to the society is not sufficient for government to intervene. So if I want to lend without collateral, I should be able to. So I am fearful, sir, that the Consumer Affairs may believe that they have a duty to say how to lend. And I think that should be made clear, that that is not their role or duty. With that, sir, I thank you very much.
Thank you, Senator Crawford. The question is, at this point in time, that the debate be suspended for a half an hour to allow members to refresh themselves. Those in favor? Against? Leader, we're taking a half an hour break here. Yes.